practice of issuing nationwide injunctions outside the confines of a certified nationwide class action is mistaken as a matter of law and unwise as a matter of policy. Let's start with the law, and in there, let's also start with the Constitution. The legislative power is granted to Congress, and what is the primary product of that legislative power? It is what the Constitution defines as a law. The term law also shows up in Article 3, but it shows up in Article 3 under the phrase arising under the Constitution, the laws, or treaties. It is not the courts that are responsible for creating the law. It's the courts who are responsible for interpreting it as it applies. But they can only do so in the context of a case or controversy, two structural limitations on what the courts can do. In other words, in order for the courts to be able to say what the law is, they have to get on the playing field, and in order to do that, you have to have a case or controversy. Now, why does that matter? Well, the Constitution does speak to this. As I've said, only the Congress can create a law. Anytime a court enters a judgment that is tantamount to being a law, the judge has gone too far. And in the case of nationwide injunctions, a judgment in favor of non-parties goes too far. You also have no statute in the judicial code, no provision in the Constitution, and no settled history at common law that allows the judge to enter these sorts of orders. That's important because everything has to fit into one of those three. Why? The Supreme Court has interpreted Article 3 in light of how it was understood in 1789. And so those are the three primary bases that you have to look to: the text of the Constitution, statutes, and English common law history. In fact, there are two Supreme Court cases that directly undermine the legitimacy of nationwide injunctions outside of certified class actions. One is Williams versus Zabarez. In that case, the court said there is no case or controversy between two parties that are in a case over an issue that has not been put into dispute by one or the other of them. It logically follows that there is no issue in dispute between someone who is a party and someone who is a stranger to the entire litigation. Similarly, at the back end of the process is the case of United States versus Mendoza, where the Supreme Court held that the federal government is not subject to the win or go home rule that you see in the NCAA postseason tournament. The government isn't stuck with whatever loss it has the first time it litigates a case to a final judgment and loses. The doctrines in the law of issue preclusion or collateral estoppel, the new and old terms, do not apply to the federal government. Why? The Supreme Court, in the unanimous decision in Mendoza, said they do not. Why? Because there are a variety of good policy reasons why it shouldn't. With that, then let me turn to the policy reasons that show this practice is unwise. There are several, okay? First, mandatory injunctions prevent the percolation of issues in the lower court that the U.S. Supreme Court in Mendoza said is necessary for that court to be able best to resolve whatever legal dispute there is. It allows the court to be sure that all of the issues, all of the sub-issues, all of the arguments pro and con, all of the benefits and costs of whatever rule are fully aired. Secondly, it encourages judge shopping. All you have to do is find one favorable judge, and you can stop an entire administration in its tracks. And as you know, it has happened to every administration over the course of this 21st century, from the George W. Bush administration to the present. Each party has been subject to this practice. Third, it can result in conflicting nationwide judgments. You can wind up with injunctions going one way and the other way because a court in Maine and a court in Alaska can come out the opposite way in a case. Finally, they are going to weaken the doctrine of stare decisis, because as the Supreme Court comes to realize, if it has to decide issues at a preliminary stage of the case without the guidance of the lower courts, they're going to have to overrule some of their decisions. Let me end where I began. This practice is mistaken as a matter of law and unwise as a matter of policy. Thank you.